from the list, may I mention one matter has come up on my mentioning today.
Serial number?
65. I have informed the other side.
What is the matter?
But the matter is, when there was a stay granted in the matter, it's a maintenance matter by this Honorable High Court. Now, they did not choose to get it vacated from this High Court, they got it vacated from the lower court. So we have filed an I application, despite they were not ready to argue the matter before here. So they got the matter vacated in the court below, before the Principal Judge Family Court Ranchi, and the stay has been vacated. And just before the holy vacations. So I had to mention it and get it listed.
Who's this? Private party has appealed?
Yes, we have informed him also.
The records have come?
Yes, everything is there. So
We'll hear it finally tomorrow.
tomorrow.
Tomorrow?
कल छुट्टी है.
Monday को सुन लेते हैं
हाँ,
finally.
Monday को सुनिए.
Get a slip?
But then once they have issued, they have got a distress warrant issued.
चलिए आज ही सुनते हैं 2:15 बजे. Finally बुला के लेके आइए.
ठीक है.
Judge for the matter from Lordship's today's daily list, serial number 41, and be permitted to withdraw.
Serial number
41, yes.
Are you for the respondent?
No, Lordship.
Okay. Are you advocate on record?
Yes, sir.
Any interim order?
No.
The learned counsel for the petitioner, Mr. Krishanu,
Great.
seeks permission to withdraw this petition. State. Considering the prayer for withdrawal, this petition is dismissed as withdrawn. Communicate. Prayer from the. It's a very small prayer. आप लिख लीजिए. This revision has been filed against order dated 11/4/2019, passed by Learned Principal Judge, Family Court, Sarekela, Kharsawa, in OM number 36 of 2016, whereby petition filed by the opposite party number 2 under section 125 CRPC has been allowed.
Serial number 11. The parties have settled their dispute outside their court and they have amicably settled their dispute.
You are there?
Petition do not want to pursue this matter. Serial number 11.
Do you want to withdraw it?
Yes, sir.
Serial number 11. Where is that, sir?
No, sir, it's for
You
the first
solicited withdrawal?
Yes. नहीं, खाली ये लिखा दिया ना कि उस पे
नहीं,
instruction
हम
the parties
ऐसा
have.
कुछ नहीं लिखाएंगे. आप लोग क्या किए? We do not know. I will just record your submission. But
Yes. Only my submission may be recorded and maybe.
The learned counsel for the petitioner has submitted that he has been instructed not to pursue the present revision application, and he has received further instruction that the parties have settled the matter outside the court. What is the matter?
125.
120. Since the petitioner does not want to pursue this case, this revision petition is dismissed as withdrawn.
Is it out of the list mentioned CRMP for restoration of revision? Out of the list.
Yes,
Okay,
okay.
madam, from serial number 10. This manner, the order has been passed by this honorable court to issue notice upon the respondent number 2. Unfortunately, madam, the order could not be complied till today. And I want
Mentioning rejected.
I want to comply the order.
You come when the case is filed.
May I mention one case from the list, serial number 29. This seems it has been wrongly listed because this case has been wanted to be listed along with 544 in 9/5/2024.
चेक करिए. ऑर्डर तभी पास होगा जब केस कॉल आउट होगा. ऐसे फाइल निकाल के ऑर्डर नहीं कर सकते.
From the supplementary list, under heading for orders, item 1, criminal revision 281 of 2021.
Yes, petition.
Fight for extension of time of your lordship's order. And because of the day before yesterday, both the parties have come to this court, your lordship, and for compromise, talk of compromise going on between the parties, and they have decided the opposite party number 2 has agreed to give 3 months to arrange the payment.
You have filed your petition yesterday only.
Yes, sir. yesterday only.
But you have not deposited the amount.
Yes, Lordship, that's why I am seeking
And
the
even
extension of time.
50,000 you have just prepared a draft. You were supposed to deposit it in the court.
Lordship, the amount has been given to the Mohan Prasad itself, Your Lordship, as because they have agreed to.
We do not know. You cannot flout the orders like this. It is one thing to say that you deposit the amount in the court and you file a joint compromise petition. That yes, this much the person will be entitled.
Then Your Lordship, 3 months time may be given. Your
I will
Lordship.
give you time, but this is not the way in which
I
you
will
comply the
deposit.
court's
I will
order.
deposit you for the
Yes.
registrar general, Your Lordship.
Once you
But 3
deposit
months-
and then you enter into whatever
Yes,
compromise
Lordship.
settlement.
Then
whatever.
Your Lordship, 3 months time may be given.
Are you for OP number 2?
Yes, sir.
Are you ready for a
Yes.
compromise?
Yes.
For how much amount?
455 lakh Lordship and 50,000 is paid Lordship yesterday Lordship.
It has been paid to you.
Yes, demand draft Lordship.
Okay. Then I'll do one thing. How much time do you need to?
3 months, Your Lordship.
3 months
For settle the amount.
4/7/2024 तक जमा करने का
Given the date also, Your
Just
Lordship.
for-
Just a minute. I will extend the preemptory order, right?
Yes.
And in the meantime, you may file joint compromise petition,
Yes.
right?
Yes.
That would be better.
Yes.
Then preemptory order need not be complied also. And then you have to file a petition seeking exemption on account of compromise. This is one way it can be
On
resolved.
the exemption petition, Your Lordship had passed previous order. Your Lordship.
Okay, on exemption petition.
Yes, sir. That is on IA number 468 of 2020.
Then you better deposit and whatever be the compromises.
But only 12 weeks time may be given, Your Lordship. Only.
You have received 50,000.
50,000 yes.
Only 4 lakhs. That has to be deducted by 50,000.
Rest of
4
the
lakh
amount
50,000.
4 lakh 50,000.
Rest would be 4,50,000.
Yes, sir. That I have mentioned in para 4.
IA number 3337 of 2024 in criminal revision number 281 of 2021. The learned counsel for the parties are present. The learned counsel for the petitioner submits that an amount of rupees 50,000 has been paid to the opposite party number 2, and the learned counsel for the opposite party number 2 has submitted that the amount has been received. The learned counsel has submitted that as a condition for exemption from surrendering, an order has been passed to deposit an amount of rupees 5 lakhs before the learned registrar general of this court by 4/4/2024. And in spite of best of efforts, the amount could not be arranged. The learned counsel has also submitted that the talks of compromise are going on between the petitioner and opposite party number 2. The learned counsel submits that 3 months' time be that the order
Have the next order, Your Lordship. Page number 10.
the order dated 7th March 2024 be extended by a period of 3 months, and in the meantime, he shall deposit the remaining amount of 4.5 lakhs before this court. Right? The learned counsel appearing on behalf of the opposite party, number 2, has no objection. He has also submitted that talks of compromise is going on between the parties. Right? After hearing the learned counsel for the parties and considering the facts and circumstances of this case, the time granted to comply the order dated 7th March 2024 is hereby extended till July 4th.
Yes, Lordship. That is stated in my petition.
4th of July 2024. Pose this case on 5th of July.
Public.
Under heading for press
Just a
time.
moment. Pose this case on 5th of July if the order passed by this court is complied
Yes.
within the extended period. The preemptory order will continue otherwise.
Yes.
Under heading for fresh filing, item 2 WPS 7450 of 2023.
Where is the petitioner?
7450. Study itself already they have filed a counter affidavit and 2 counts they are taken. They have taken. Only for the reason which my candidature has not been considered by them. Only for the degree, because of the degree of Hindi Vidyapith. And that has already been satisfied by the several decision of the different bench also. I will bring on record. And second, they are
You
saying.
want to file a rejoinder to this?
Yeah, that's not a fine.
The learned counsel for the parties are present. At the prayer of the counsel for the petitioner, the matter is adjourned to हम लोगों ने एक में डेट दिया है ना कल हिंदी विद्यापीठ का we have yesterday we have posted one Hindi Vidyapeeth matter Mr. Manoj Tandon का केस है ना देखिए सर
Price chart.
23/4 24 in the meantime if so advised the petitioner may file the rejoinder by 18th of April.
Under heading for admission, item 4 WPS 447 of 71 of 2023.
एक रिपोर्ट मंगाई थी ना?
Yes, sir.
Third round of litigation. First round of litigation, I was told the Honorable Writ Court with the same set of prayer, whereby the Honorable Writ Court has directed
Just a moment. Where is the first order?
yes, page 190,
Writ number?
page 119, annexure 12. Writ number is 4581 of 2019.
4581.
4581, sorry. 4581 of
Date of disposal?
date of disposal is 27/1/2021. Thereafter, due to some typographical error, the CMP was filed.
by which notes the order was modified.
That's it. You were para teacher,
I was para teacher,
applied under?
non-para category. I'm not taking the benefit of para.
Your candidature was rejected on what ground?
Firstly, when I filed the writ at that time, they were not considering, there was no reasoned order. So the Honorable Writ Court has directed to consider my case in light of the judgments passed by LPA Court and other writ court. Thereafter, my lords, I have
But
filed.
they had come up with a plea that your certificate was that you had not taken the permission, isn't it?
Yes, as a regular candidate.
That's right.
That's
They had taken that plea in the counter affidavit.
The counter affidavit, then also notes the Honorable Writ Court said that there is a judgments of Writ Court and LPA. You considered his case in accordance to with that. Thereafter, contempt filed. One reason order was there placed. It was again withdrawn by the intervention of court. Again, a fresh reason order was passed. Again, it was withdrawn. And finally, the third reason order was passed, which I have taken the liberty and challenge before this writ petition, which is impugned here. And the ground is only that I have done my intermediate course as a regular candidate in the year 2004-2005, but I have taken the permission, which they have not disputed, from the village committee for doing that particular course. And they are saying that no, you cannot be.
When did you take the permission?
Yes. (16/6/2003), page number 53. 16 by letter date 16/6/2003. Annexure 7 series.
Where is the discussion of this document in the interim order? I have read it.
Yes,
You also read
there
it.
is no notes.
No discussion. You never produced it also before then. It was not even a part of your earlier writ petition. No such plea was ever taken in your earlier writ petition. Now you are cooking up a new case altogether. Then
Must be there in the rejoinder.
you just find it out. The earlier records are there. Come at it. ये सारा रिकॉर्ड देख लीजिए.
Yes.
अभी तो पुराना रिकॉर्ड अभी लेकर आए.
Yes.
I don't know.
From the daily list under heading for final disposal, item 1, criminal division 109 of 2019.
This case is convicted under section 279 and 304 A of the Code. Is sentenced to undergo SI for 6 months and 1 year. But the appellate court has dismissed the appeal, but modified the sentence from 1 year, from 2 years, 2 years to 1 year, and from 6 months to 4 months. The maximum sentence which has been awarded by the appellate court is 1 year, and he has remained in custody for more than 6 months. And there are various matches in the case, Your Lordship, that since the petitioner, since the informant was well known to the petitioner, Your Lordship, but he has not been named in the FIR, Your Lordship. FIR against here no. And in deposition, he is saying that he was knowing him from last 20 years.
We are in revision.
In revision, Your Lordship.
So you better confine your arguments to the scope of revision jurisdiction. He is not the only eyewitness. There are other eyewitnesses to the argument.
But they have
In your 313, you never said that.
I have stated that I was not driving the vehicle. In 313, I have stated, Your Lordship. And Your Lordship, main thing is that neither doctor has been examined nor IO has been examined, Your Lordship. And the
How does that make a difference? Death had happened?
Your Lordship,
Somebody had died?
a little boy.
Death is disputed?
That is not in dispute. But my submission was that I was never driving that vehicle, Your Lordship. I was not driver at that time, Your Lordship.
दिखाई दे.
And in 313 he has stated. And Your Lordship, post-mortem report. Post-mortem report has been exhibited, Your Lordship, not by the doctor who has conducted post-mortem report. And the formal witness has not identified the signature of the doctor who had conducted the post-mortem report, Your Lordship. And MVI report is not on the record, Your Lordship.
Death cannot be proved without the post-mortem report.
You know, that is not, but Your Lordship, one cannot be convicted under section 304A without post-mortem report, Your Lordship.
Show me some law that one cannot be convicted under 304A without a post-mortem report. When you make a statement, show me some law.
And
Please don't make a statement like this.
MVI report is not on record, Your Lordship, that whether there was any mechanical fault or not. Neither the MVI has been examined nor his report is there on the record, Your Lordship. And now he has remained in custody for 6 months, Your Lordship. Out of 1 year he has remained in, maximum he will be awarded, he will have to remain in custody for 9 months, Your Lordship, out of which he has already remained in custody. And when he was granted bail, Your Lordship, by this honorable court, rupees 50,000 was deposited by the direction of the honorable court, which was given to the parents of the deceased, Your Lordship. And now he is 67 years old, Your Lordship. He is not suffering from various ailments, Your Lordship.
The breakdown of, there was a breakdown of the vehicle,
There was breakdown of a school vehicle, Your
school vehicle,
and
not your vehicle.
not my vehicle, Your Lordship. And the boys were hovering here and there, Your Lordship. In the meantime, the Savari Gadi which was coming dashed one of the boys. Saksham Kumar, Your Lordship.
The postmortem report was exhibited by a doctor.
Exhibited-
Maybe not the same doctor who had conducted the postmortem.
But he failed to identify the signature of the doctor who conducted the postmortem report. Has it maybe said
No,
that?
no, he has said so.
I have the judgment में.
जजमेंट में क्या पोस्टमार्टम यही देख ही रहे हैं उसका डिपोजिशन.
But that was exhibited with protest.
That's
Since he did not identify the signature of the doctor, original doctor who had conducted the postmortem. And MVI report is not on record.
without MVI report, a person cannot be
You know,
convicted.
by that it was to be found there that whether there was any mechanical fault on the.
It was a spot death.
Hi, he was brought to the hospital where he was declared dead. On the point of sentence, Your Lordship, he has already remained in custody for 6 months, Your Lordship. And by the direction of the Honorable Court, Your Lordship, he had already deposited rupees 50,000.
He has deposited or he has given it to the victim?
It has been given to the victim.
From where do you see this?
I have asked him, Your Lordship.
आज स्टिल चलता है क्या?
Let-
आप अपना वर्बल सबमिशन कुछ भी करते रहिए, है ना?
No, that was given to the.
From where do I get this?
I have document, Your Lordship.
विक्टिम का तो डेथ हो गया, तो किसको दे दिया?
Victim के parents.
कहाँ से बोल? कहाँ से? Yes.
Your Lordship, document is there, Your Lordship, that he has already deposited, Your Lordship. But whether he has taken the money, that is not on record, but he has withdrawn that amount.
That is why he must have been released on bail. So please don't tell us that you have given it to the victim, father of the victim, right?
He has taken from the court.
He is taken from the court.
Yes.
How? Under whose orders can he take the fine amount from the
It
court?
was in the order sheet, Your Lordship. See, currently see order dated 18/9/2019. Paragraph 4, Your Lordship. Petitioner is directed to deposit a sum of rupees 50,000 by check or by cash at the time of filing of bail bond as victim compensation. The said amount will be disbursed to the victim parents of the deceased after proper verification and identified by the court.
What is the age of the petitioner?
Petitioner is 60. At present, he is 67 years old.
Any other case?
No, there is no other case.
What is the date of FIR?
Date of FIR, Your Lordship.
Two 2008.
2008, 8 to 2008, Your Lordship.
How many years have expired?
16 years, Your Lordship. More than 16 years.
You see, in a case of hit and run,
Your Lordship.
in a case of hit and run, normally I do not give less punishment than 1 year. But 50,000 you have already deposited. Where is the APP? Absent.
In this case, not in the larger case.
Yes.
Second image, the ex-APP is the transfer of the case.
Nobody
When
is
the kindly
available.
pass on for few cases, I will inform.
I do not know. Nobody has come. This matter is listed in the supplementary list.
Lots.
So we can't do anything about it. We have to record his absence only. We will not permit proxy appearances. You are not ornamental to the court.
He has already deposited 50,000.
Only pass off for few cases first. I will inform.
By the time I dictate the order, if he comes, I record his appearance. Otherwise, we will not. So you will confine it to the sentence? I'll confine it to the period undergone, but you have to deposit more 50,000.
He is
1
not-
lakh compensation.
He is not in position, see the condition.
If he is not in position, then jail is a better place.
थोड़ा इंस्ट्रक्शन ले लेंगे
इंस्ट्रक्शन की कोई जरूरत ही नहीं है क्योंकि हम डिफॉल्ट क्लॉज भी देते हैं साथ में. जमा कर देंगे तो अच्छी बात है और नहीं जमा करेंगे then he will serve the remaining sentence, right?
25,000.
बार्गेन नहीं हो सकता.
Considering
आपको
the-
मैंने बता दिया
Yes.
आपके क्लाइंट भी बैठे हैं. You see my all the orders consistently in a case of hit and run.
I know.
If a person takes the victim to the doctor and does something for him, तब हमको उसके साथ सिंपैथी हो सकती है. लेकिन क्रश करके भाग जाने के साथ हमको कोई सिंपैथी नहीं. The appellate court has already granted you relief and reduced the sentence to 1 year, right? So ample sympathy has already been shown by the appellate court. In order to have further sympathy, so you have to.
Considering the age of the appellant.
I will consider his age. 67 years कोई ऐसा age नहीं होता आज के ज़माने में.
लेकिन he is suffering from very gall bladder का just.
कोई बात नहीं, 1 लाख रुपए देना होगा.
Operated.
अब तो बच्चे भी बड़े हो गए होंगे. They should help. लिखिए. I will confine it to the point of sentence. Criminal Revision number 109 of 2019. The learned counsel for the petitioner is present. Nobody appears on behalf of opposite party state. This revision petition has been filed against judgment dated 13/12/2018, passed by learned additional Sessions Judge Roman 2 Koderma in Criminal Appeal number 41 of 2017, whereby the appeal preferred by the petitioner has been dismissed, but with modification in sentence. The judgment of conviction and conviction dated 25/5/2017, passed by learned Subdivisional Judicial Magistrate Koderma in Koderma PS case number 45 of 2008, dated 8/2/2008, corresponding to GR number 65/2008 and GR number 530 of 2017, registered under section 279 and 304 capital A of IPC. The petitioner has been convicted under under the aforesaid 2 sections by the learned trial court. The learned trial court sentenced the petitioner to maximum punishment of 2 years. However, the appellate court has reduced the punishment to 1 year and SI for 4 months under section for 1 year under section 304 capital A and SI for 4 months under section 279 of IPC. The learned counsel for the petitioner has submitted that he shall confine his argument to the point of sentence. The learned counsel has submitted that the FIR in the instant case was instituted as back as on 8/2/2008. And while the school bus went out of order, the children were coming out of the vehicle and the vehicle involved in the present case bearing number JH12B-5011, which was alleged to be driven speedily and negligently by the present petitioner, dashed a child, due to which he got injured, and when he was taken to the hospital for treatment, he was already dead. The Learned Counsel has submitted that the petitioner अब भागे नहीं ना थे at any point of time.
I was not there, Your Lordship.
No. I don't want to say. I want to. You surrendered in 2008 itself. I want to know that you cooperated with the trial. I suppose.
I had all.
At any time you did
No,
not.
never.
You were not declared absconder. That's it.
One thing more, Your Lordship, हमको ample of time मिलना चाहिए for deposit.
आपको देंगे. हम अपने से देते. The Learned Counsel for the petitioner has submitted that the petitioner had surrendered before the Learned Court on 2/5/2008 and has faced the trial for long years, inasmuch as the conviction was recorded only on 25th May 2017. The Learned Counsel has also submitted that the present case is the first offence of the petitioner, and he has already remained in custody for a period of
More than 6 months.
more than 6 months. And the present age of the petitioner is 67 years. The Learned Counsel has submitted that at the time of grant of bail by this court on 18/9/2019, the petitioner was directed to deposit a sum of ₹50,000 by cheque or by cash at the time of filing of bail bond as victim compensation, and the said amount was directed to be remitted to the parents of the deceased child upon due identification. The Learned Counsel has also submitted that though the appellate court has reduced the sentence to some extent, but considering the long drawn litigation and expiry of 16 years as of now from the date of the incident, some sympathetic view may be taken, and the petitioner is ready to abide by any further condition that may be imposed by this court.
हम पूछ लेते हैं
पूछ लीजिए.
और he is suffering from kidney problem. There are he has just been operated. You know, उसका बहुत simple.
हम सरेंडर करने तो नहीं बोले.
तो उसको वो भी पोजीशन नहीं है जेल में सर. तो इसको 25,000 हम्बल प्रेयर था ये लॉर्ड.
बार्गेन नहीं हो सकता. बार्गेन नहीं हो सकता. हम केस मेरिट में डिसाइड करेंगे. तो फिर हम फिर से लिखाना पड़ेगा.
नहीं तो नहीं डिपॉजिट करेगा. नहीं करेगा तो ही भी फर्दर सर्विंग द
The learned counsel for the नहीं after hearing the लिखा दिया ना वो any condition वो मत लिखाइए लास्ट वो मत. That sentence को हटा. After hearing the learned counsel for the petitioner and after going through the records as received from the learned court below, from the concerned court, this court finds that the FIR was instituted as back as on 8/2/2008 and the case was registered against the petitioner who was said to be the driver of the offending vehicle under section 279 and 304 capital A of IPC, and after investigation charge sheet was submitted on 31/3/2008 under the aforesaid sections. The cognizance was taken on 12/1/2010 and the substance of accusation was read over to the petitioner who pleaded not guilty and claimed to be tried by order dated 7/1/2013. The prosecution produced altogether 6 witnesses and documentary evidences, and the defense did not produce any oral or documentary evidence. The statement of the petitioner was
I am not
recorded
on merits, Your Lordship.
under section.
He will deposit 50.
Should I record that? That on any condition you are ready. फिर भी ये फाउंडेशनल बैकग्राउंड देना ही होता है क्योंकि these timelines are important. The statement of the petitioner was also recorded under section 313 and he denied he was in denial of the incident, denial of his role. The learned trial court, after scrutinizing the materials on record, including the evidence of the eyewitnesses, found the petitioner guilty the appellate and the learned trial court sentenced the learned the findings of the learned court. The learned court recorded that in the incident, a child of 6 years of age was killed in the road accident. And this happened due to the reason that the school bus stopped when the children of the school were returning home due to defect in the vehicle, and the victim child was on the road where the vehicles used to ply at the time of accident. The petitioner was sentenced to undergo 2 years simple imprisonment for offence under section 304 capital A IPC and 6 months simple imprisonment for offence under section 279 IPC, and the punishments were directed to run concurrently. The learned appellate court also scrutinized the evidences on record and recorded concurrent findings, and considering the entire aspects as well as the nature of offence, the learned appellate court was of the view that the simple imprisonment for 1 year for offence under section 3 and 4 capital A IPC and SI for 4 months for offence under section 279 IPC would meet the ends of justice, and accordingly the sentence was modified. After going through the records of this case, this court is of the considered view that a child who remained unattended, aged 6 years of age, on the road, died on road accident. The fact remains that the petitioner has faced the rigors of criminal case for about 16 years, and he is at present 67 years of age and has also remained in custody for more than 6 months. And he has served the sentence so far as offence under section 279 of IPC is concerned. And there is no minimum sentence as such prescribed under section 3 and 4 capital A IPC. And considering the minimum sentence, considering the totality of facts and circumstances of this case, this court is of the considered view that the sentence of the petitioner requires further modification, and accordingly the sentence of the petitioner is confined to the period already undergone in custody. With fine of rupees 50,000 to be deposited by the petitioner before the learned trial court within a period of 6 months from today. The fine amount so deposited is directed to be remitted to the parents of the deceased child. This fine amount is over and above the victim compensation which has been deposited by the petitioner pursuant to order passed by this court at the time of grant of bail. If the petitioner does not deposit the aforesaid amount of rupees 50,000 by way of fine within the stipulated time, the bail bond furnished by the petitioner will be cancelled, and the petitioner would serve the remaining sentence as imposed by the learned appellate court. The fine amount so deposited be remitted after due identification. This revision petition is accordingly disposed of.
Appearance for the state lordship. My name is appearance.
Your name is appearing?
No.
No.
Shekhar Sinha is ex.
No, you are not ornamental to the court. I would have asked you a few questions. यहाँ पे ऐसा नहीं चलता कि जब if the concerned person is not there, proxy नहीं चलता.
All the cases are not ex APP and PPC discussed.
So it is the duty of the APP, it is the duty of the PP to ensure allotment of cases. ऐसे नहीं होता.
लेकिन नॉन अपीयरेंस लॉर्डशिप.
नॉन अपीयरेंस रहेगा.
क्यों नॉन अपीयरेंस करा के पीपी
ये जो ये सब VC में रिकॉर्डेड है, आप अपने YouTube में उनको दिखा दीजिएगा.
Item 2, criminal revision 812 of 2019.
Yes, petitioner.
Instant case petitioner has paid for posting or setting aside the order dated 9/4/2019, wherein the discharge application of the petitioner has been rejected by the learned additional session judge, wherein finding in connection with Kolkata PS case number 49 of 2012. The present case is at the stage of evidence lordship, and for which the next date is fixed on 2/5/2024. Lordship, the accused petitioners are Masuda Sunar, Ningni, Manu Sunar, Anu Sunar.
What is your ground?
Lordship, there is sufficient, there is no sufficient material against under section
No
3
sufficient material.
to frame charge against 307.
There is injury,
There,
fracture,
there is injury, but there's
head injury.
There is no head
We
injury.
will, there is head injury. You have not read the impute order?
May I read the FIR and thereafter the impute?
FIR will not be, is not the encyclopedia of everything.
I read the relevant para.
Anyways, we have heard you enough. Fracture is not a.
Fracture is
is
there.
a grievous
Injury. It is a grievous
That's
injury,
it.
but
That has to be
Head
seen as.
injury and the
Head
grievous
injury is
injury.
also there.
Yes,
Aches
sir.
on the head.
Page number 34 of the.
Yes, it is there.
It is a clear.
Yes, likhiye. Criminal revision number 812 of 2019. Heard the learned counsel for
may I
the
submit,
parties.
Your Lordship? One more point with regard to 307, whether 307 will be made out or not. Your Lordship, may I read the sections? Your Lordship, on which.
You want a mini trial at this stage?
No, not mini trial, but at least to see that whether that offence has caused intention, whether there was any intention to commit murder of the informant, or whether there was any such injury that will cause death. So the offence under section 307 will not be made out in this case. Whether the sections under 325 and 324 relating to injury will be made out. However, for 307 it will not be made out. So that is my point of argument.
Right. The basic ingredients of 307 is not satisfied.
Not satisfied.
Which is that ingredient which is not satisfied according to you? Yes, tell us.
May I read the
Which ingredient is not satisfied?
May I read the section of 307 so that it will be clear that
You tell us that this ingredient is necessary for an offence under section 307.
there has to be injury on vital part of the body, and that injury needs to be serious in nature. However, in the present case, Your Lordship, and that would result into death. However, there was quarrel between both the sides, for which a case was lodged by the petitioner's son, namely Your Lordship.
Is injury a condition precedent under 307?
Lordship, there has to be intention or knowledge and such circumstance that the cause may be death.
गोली मारने से 307 होता है कि नहीं? नहीं लगा. होता है कि नहीं होता? I'm asking you ingredients of 307.
Yes, that could attract, but here you have to see that.
होता है ना?
Here
अच्छी
you have
बात.
to see the exact like the
I've seen it.
case death.
Not at all. There is a head injury also. Criminal revision number 812 of 2019. Heard the learned counsel for the parties. This revision has been filed against order dated 9/4/2019, passed in ST number 131 of 2018, arising out of Barkatha PS case number 49 of 2012, corresponding to GR number 1100 of 2012, whereby the learned judge has rejected the application filed by the petitioners for discharge and has recorded that there are sufficient materials to frame charge under section 341, 323, 324, 325, 307 and 504 IPC. The learned counsel for the petitioner has submitted that there was a dispute between the parties arising out of land dispute, arising out of land, and the basic ingredients for offence under section 307 of IPC is not at all satisfied. The learned counsel has submitted that though it has been recorded that there was a fracture, but the fracture was not on the vital part of the body, and therefore the offence under section 307 is not made out. That's it. The learned counsel appearing on behalf of the respondents, on behalf of opposite party state.
One more point. There is no statement of any witness in the case diary relating to any cause injury on the head of the victim.
The learned counsel has also submitted that there is no statement in the case diary regarding any head injury to any of the victim. The learned counsel appearing on behalf of the state has opposed the prayer and has submitted that there are multiple that number of persons were injured in the incident, and the details with regard to the injury of each and every person has been recorded by the learned court. He submits that it has also been recorded that two injured persons, namely Nandlal Sonar, Lakhan Sonar, were examined by the medical officer, who initially reserved his opinion, and then it was found that there was a fracture on left medial condyle, which in his opinion was of grievous nature. He has also submitted that Ram Lakhan Sonar was also assaulted by Sanjay Sonar by means of an axe on his head with a view to cause murder, due to which he fell down. The learned counsel has submitted that at the stage of discharge only prima facie case is required to be seen, and the court is not supposed to conduct a mini trial. And the petitioner and the points raised by the petitioner are fit to be raised at the stage of trial. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, and upon going through the impugned order, this court finds that the learned court has recorded that one of the accused, Sanjay Sonar had also assaulted Ram Lakhan Sonar, who had come to rescue by means of an axe on his head, due to which he fell down. Then the informant was assaulted by Vasudev Sonar by means of club, causing fracture in his head. The learned court has referred to the various paragraphs of the case diary and has scrutinized the materials and has
Rajbir Singh versus the state of
not
UP and another.
the learned court below has considered the materials on record and has found that at the stage of discharge only prima facie case is to be seen. The standard of proof by evaluating the material as to ascertain whether there is prima facie case against the accused or not to be applied at that stage. The findings, the reasons given by the learned trial court is quoted as under. This court finds that the learned trial court has passed a well-reasoned order, and this court finds no illegality, perversity, or material irregularity in the impugned order, and therefore the present revision is hereby dismissed.
Submit on your lordship.
However, sorry,
With regard to role of the petitioner
Which-
number 2 and 3, that is monosonar and anusonar. Nothing has been stated
no,
in the impugned
we
order,
can't segregate like
and
this.
only against
Let this
Vasudha
order be
Sonar and
communicated
Sanjay Sonar
to
it has
us.
been stated.
After
So
the
that-
order, there is no concept of arguing much more than
Your
whatever
lordship,
you
I
have
was,
argued.
I was supposed to submit, but due to the pronouncing of this order, I was not able to.
I've
That is the
given you
reason,
enough
because we have to
time.
see-
I'm
We
hearing
have
you
to
for
see the
last 10
prima facie
minutes.
whether the allegation is based against this petitioner number 2 and 3 or not. If this is not made out, this impugned order will not sustain your lordship.
We'll see
So
that. The court will see everything.
petitioner number 2 and 3, because allegation is against Vasudha Sonar and Sanjay Sonar.
There is no concept of argument after the dictation of the order.
Item 3,
But I was
Yes.
criminal division 446 of 2020.
Okay. Yes, petitioner.
Before opening my argument, just want to give some brief dates and background of the case. There's a division has been against the order of the maintenance. So I'm just stating some relevant dates. The date of marriage of the petitioner and the OP number 1 is 24/1/2006. Thereafter, in the year 2009, a maintenance case has been filed, which has been case numbered as maintenance case number 177/2009. Subsequently, it has been disposed in the year 2013, 23/11/2013, on the basis of the compromise. And between that, one complaint case has been also filed by the complainant for 498A, with complaint number 2502 of 2009, which is also been disposed of by compromise on the very same date, 23/11/2023. Thereafter, one son has been born during the wedlock. So the date of birth of the son is 1/10/2014. After that, it has been alleged that the OP number 1 has been ousted from her matrimonial house on 24/10/2017. Thereafter, another case has been lodged in Chirkunda PS, being Chirkunda PS 218/2017 on 21/10/2017. And it has been alleged that since then she
218 of
2017 Chirkunda PS case number
under section
under section
498A
498A.
and
and-
other sections also.
Perhaps
Okay, anyways.
498.
Then-
Thereafter, it has been alleged that since this date they were living separately. And on 9/10/2018, this maintenance case has been filed 302/2018, which is the order of this which is challenged here under. And after the pronouncement of the judgment, the Chirkunda PS case has been disposed of, and I have been duly acquitted in that case.
When were you acquitted?
Yes, I was acquitted by order dated 11th May 2022 by CGM Dhanbal, by the learned CGM Dhanbal. And in that case, she never appeared to depose her statement. Only one witness has been examined in that case, and thereafter I have been duly acquitted on contested acquittal. It has been contested acquittal.
Who contested the case? She never appeared.
She never appeared in the crime. One witness has been examined, and that has been disposed on the contested. I have contested the case. She never appeared, and it goes in my favor.
That's right.
So it is contested acquittal. And in this case, once it has been sent for the thereafter, in this case, she has deposed two witness. Witness number
We are
1.
not concerned. You have been acquitted on 11.
No, now I am concerned with this case. I am arguing a maintenance case. In this maintenance case, two witnesses have been examined. One is the applicant Roshan, the OP number 1, Roshan Ara, wife of the petitioner, and Aftab Alam, the brother of the OP number 1. Both witnesses have examined in this case. Thereafter, the order has been passed ex parte, which is under challenge before Your Honor. I may be permitted to read the judgment.
You just tell us I've read it. You tell us what is your point.
My point is, Your Lordship, that the ex parte order which has by the service report is not there. Only the statement that it has been registered. I'm just reading the exact line. That it has been sent. Registered track shows registered notice received of the allowed ex parte, and there is no service record.
What is track?
I don't.
You don't know tracking report?
Tracking report is that whether it has the notices have been served by both process.
No. That is tracking report. You go to the net, you get everything
Yes.
in the net.
But it has not in the record. The tracking report is not in the record. That whom the notice has been served. Whether I personally take
It is always indicated served on the addressee. You have never tracked your service speed post or registered post.
It is registered post. It's always
Even there is a
it's
tracking
always a
report
mark
of
that
registered
the
post
state
also.
person in this address has been
कंप्यूटर के सामने बैठते नहीं हैं.
रजिस्टर फिर भी हुजूर एक बार देखा जाएगा इसमें कि as per the service report is not there. The performer of the service report. I'm just concerned about the.
आप पिटिशनर के फेवर में बहस कर रहे हैं कि अगेंस्ट में बहस कर रहे हैं?
No, I'm just.
I will, if I remand this matter, तो compensation जो आपका maintenance amount है ज़्यादा fix हो जाएगा. Fix हो जाएगा. The maintenance has been awarded from the date of the order, and then you will have to disclose all your assets.
I have already disclosed. It has been
Before
disclosed.
whom have you disclosed?
The superintendent of police has.
Superintendent of police, how are you concerned? You have to disclose on affidavit before the court.
Yes. Now,
You're happy with that?
No, why order?
It is hardly any amount has been given to us, given to her. Are you an unemployed person?
Yes.
Yes. From where do you say?
From the report. Report R.
Report.
Flag R is the report. Flag R is the report of the superintendent of police.
Flag R.
Yes. Flag R. The report of the superintendent of police.
It is not a part of the record.
It has the inquiry has been conducted by on the basis of judicial order. By judicial order.
Which order?
That's order number 8. Order number 8, dated 14/12/2023. The only direction was to ascertain his properties. Now, what the police has done, they have taken a statement like 161, and today the petitioner is referring as it. This is the evidence which can be considered. Order number 14 was because on that day 3 lakhs was outstanding. So, Honorable Court has directed the SP to ascertain what are the properties from which realization can be.
No. Even I may permitted to read the deposition.
Which
deposition of the opinion board.
Before the learned court?
Before the learned court. She has not given any document relating to the.
You forget about it. Even if you are unemployed, the amount is a meager amount. What is the minimum wages?
472.
Per day.
Highly skilled.
Per day.
Per day.
What is the monthly wage?
Monthly is 26 multiplied. Near about 11,000 per thousand.
No, more than that. If it is 500 rupees, then it will be around 15,000 rupees.
15,000.
How much has been awarded?
6,000.
So
5,000 for wife and 15,000.
Even if we take minimum wages, then also it is a meager amount. On quantum, it is very difficult.
It may be then it may be limited back so that I can depose my witnesses and it would be for the
वही तो पूछ रहे हैं. जब remit होने के बाद जो fresh order होगा ना, it will be from the date of application.
Okay.
You are happy with that?
No issue for that.
Yes. What do you say?
Let's see the order dated 30th August 2023 and thereafter 9th November 2023. The interim order was vacated because he was directed to deposit certain amount. That was also not deposited, and thereafter this Honorable Court has vacated the interim stay granted in there on 9th of November 2023. Now the question is, whether the notices was validly served or not. But the track report was there, the tracking report was there, which was considered by the court. Now, my lords, this is a proceeding which is, my lords, is not, will be guided by issuance of summons and warrants to them. It's a key to the proceedings, my lords, it's a summary in nature before the
That's right. But tracking report is not there on the record.
It's the
The LCR is here. Tracking report is not there on the record. Dikha didn't.
But my lords, it is categorically
Maybe
stated.
mentioned, but that report should have been placed on record, isn't it?
It appears from mail tracking report. That is the
No.
what's written. So
A print should have been there. Where is that? It is not there on record.
the LCR which is sent is a part of order sheet, exhibits and deposition. As the Hajiris are not there, these tracking reports will never come unless the original LCR will be called. Because whenever the Xerox copy of LCR is called, it is only
From
the
where do you get this? What do you say on the tracking report? It is not there. What are you showing?
I am showing the service report of the High Court on this performa. I couldn't find it in the LCR. The performa, on the basis of this performa, I am just making my argument that if it is available on the record, then it will reflect that.
Others may call the original LCR. That must be there because it can't be written like
Just
this
a
by the.
moment. To me, revision number 446 of 2020. The learned counsel for the petitioner has submitted that the impugned order is an ex parte order and it has been recorded
Paragraph 3.
in paragraph 3 that that it appeared from mail tracking report that registered notice was served upon the petitioner. The records from the learned court, a photocopy of the records from the learned court has been received, but the record does not contain the tracking report. The learned counsel for the opposite party, number 2, has submitted that the tracking report must be available
In the original
records, and therefore
The
either
entire
the original records be
The
submitted,
entire original records.
either the entire original records be submitted or the learned court be directed to provide a copy of to send a copy of the tracking report. Tracking report agar aa gaya,
That is
तो
there.
आपका
Otherwise,
case हम
principal
discuss
district judge will never write that it appears from tracking.
the office is directed to call for the tracking report from the concerned court, which has been mentioned in paragraph number 3 of the impugned order. Let this order be communicated through fax. Pose this case on April 25th in the supplementary cause list.
Item 4 WPS 1291 of 2023.
Yes, petitioner. But this case will be taken up today. Come at 1 o'clock.
Item 5 WPS 6693 of 2023.
Was in terms of your lordship's order, the IA as well as the rejoinder were filed 3 days prior to the time fixed by your lordship.
Yes, respondent, why don't you comply with the court's order?
There was no direction to file the IN so far as the rejoinder is concerned. I have not received any response.
You have read the last order?
Response is any.
So you don't want to file any response?
Yes, after the chief secretary, the benefit the chief secretary, the committee report, as per your lordship's direction.
No further counter is required. Okay, so this matter can be heard without any controversial.
But my lord, in the IA petition.
We do not know. We do not know. You have not responded to the IA. So firstly, the IA is to be allowed without any response, right? Then how much further pleadings are you?
Yes, challenge the.
I have only indicated in para 5 the various subparagraphs of the pleading, which are all based on records, my lord. Perusal of the so-called resolution notification dated 5/7/2002, provisions of the Jharkhand Public Work Department Code, which is already a word in the writ petition. Then my rules of executive business, which are not new facts, because the orders which were passed conferring promotion to me on the statutory cadre post, they are all of them.
Where is the portion of the pleadings which you are seeking to amend?
My lord, sir, the pleadings basically are, my lord, if your lordships will kindly see.
Which paragraph?
Para
Which
5.
are those paragraphs which you want to insert?
My lord, yes. My lord, para 5.
Para 5.
Para 5, 6 and 7. These are the three paragraphs. 6 is based on the supplementary counter-affidavit covered under the rejoinder also. We have also filed a rejoinder. Para 5 read with relief, para 1 and 7.
First para 1.
Para 1 and para 7.
Para 1.
Para 5, 1 and 7.
Yes.
So basically the further pleadings which you want to incorporate is there in para number 5.
Absolutely. And no, sir, only for the
Who has
purpose.
drafted this petition?
No, sir, if it's not good, my lord, then I'll say I drafted it.
Because this is not the way in which an amendment petition is to be drafted.
My lord, kindly see the prayer 1. And if your lordship sees the prayer, it is for a declaration to hold that the resolution pursuant to which a conscious decision was taken in the supplementary counter affidavit enclosed as A1 is not relatable to the statutory cadre post. And therefore, and it's not a declaration with regard to equivalence. And then para 5 sets them all out.
The relevant part of the para 1, it is at page 4 of the IA petition.
Now this IA is to be allowed to be treated as a part of the main petition. That's it. And then he will argue the matter. That should be sufficient. IA number 3076 of 2024. The learned counsel for the parties are present. The learned counsel for the petitioner, learned senior counsel for the petitioner has submitted that the interlocutory application has been filed, inserting with a prayer to insert. The interlocutory application has been filed on account of subsequent developments which has taken place during the court proceedings, particularly with regard to the supplementary counter affidavit filed by the respondents and the decision taken by them by constituting a committee
Those committee was constituted by my lords. They only sat down and took a conscience.
By virtue of, on account of the decision taken by the respondents as annexed with the supplementary counter affidavit. The learned counsel submits that the relief sought for through the interlocutory application is a sequel to the main relief as prayed for in this writ petition, and therefore the prayer for amendment be allowed. He has submitted that in spite of orders passed by this court, no response has been filed to the interlocutory application. The learned counsel, appearing on behalf of the respondents, has submitted that he has no serious objection to the interlocutory application seeking amendment, and no specific reply is required to the averments made through the interlocutory application. Correct?
Yes, but one point I would like to indicate.
No, we will hear you whatever point, but so far as reply is concerned, that is not.
In this amendment itself, my lord, whereas my senior has not been briefed properly. But in the amendment petition or in the writ petition, they have heavily relied on 2016 engineering service rule. My lord, yesterday I got, my lord, one resolution of the state government, where it is of 7/3/22, which stays the 2016.
I do not know. You have not responded to anything. What is this? Yesterday you have got
But
something.
it will not change the post is that. Yes.
I remember Milo's 1990 Supreme Court judgment, which brought about a subtle differentiation between a stay and a
IAM, Malad can say I have not replied.
Yes. Okay.
But Malad in the writ petition also, Malad relied on this.
So in the main counter affidavit, you must have said that it has been stayed,
No.
isn't it? In the main counter affidavit.
Malad, it was not.
So, how are we concerned with that? Who has stayed that? A judicial order?
No, some writ petition are pending. In the light of the pendency of the writ petition, the government had decided to stay the 2016.
Which writ petition is pending?
Yes, it is mentioned in the resolution. Writ petition number 3027/2016 analogous question.
इसका जरा status बताइए.
Let me try to understand. My learned friend rightly commented that I have not been properly informed. Even if I was so properly informed, a stay doesn't wipe away the rules. Stay only, and that too by an executive order.
It was my duty to point out.
We do not know. We only see the records. Right? We only see the records. Tell your officers, we go strictly by the records. Things which are not on record, please don't argue on those.
Yes, madam, we will proceed on the basis of the record.
Whatever is records,
Yes,
right? Considering the aforesaid submissions, IA number 3076 of 2024 is hereby allowed and is directed to be treated as a part of the main writ petition. When do we hear it finally? When do we hear it finally?
Because I am prepared today.
Since I was expecting a adjournment from their side.
Because I know.
So,
Because could I just say Minos?
I'll give a very very short date.
Minos, yes.
कब बताइए? इनका जो date सूट करेगा?
Any date will also today itself I can argue.
You are ready to argue it today?
On the basis of the records.
Okay.
But if any short date is
Just no. We will commence the argument. I'll just find it out, the contours of the case, and then I'll post it. By that time, I will be better prepared to decide the
Minos,
issue.
could I make one prayer? Minos,
Yeah, you just hold on for a minute. With the consent of the learned counsel for the parties, the hearing of the present case has commenced.
Minos, your lordships will see that the challenge, let me give the contours, Minos, first, as your lordships right now not set it out. Challenge is to Annexure 17, which is at page 77, not, which itself speaks. Not your lordships will not go to the records. I'm just only delineating the salient features. Not the order of transfer itself says that the petitioner, Murari Bhagat, who was posted as engineer-in-chief cum additional commissioner cum special secretary in the Rural Works Department. His services has been recorded and he has been transferred and posted as engineer-in-chief in the technical cell examination of the Vigilance Department. Because the contention in short as raised in the writ petition was that engineer-in-chief is a non-existent post. Under the statutory rules 2016 Jharkhand recruitment rule, the cadre post is a post with the nomenclature of engineer-in-chief cum AC cum SS, and the promotion is granted from the feeder post of chief engineer. So a chief engineer
But how do you say that engineer-in-chief is a non-existent post?
Simpliciter, the engineer-in-chief under the Jharkhand the Engineering Service Rule 2016 is a non-existent post. Schedule has the nomenclature, I will refer to that. Because the feeder post for grant of promotion to the post of engineer-in-chief cum AC cum SS is the post of chief engineer. There is no post or designation as engineer-in-chief simplicity. Then, my lords, we had set out that the petitioner earlier pursuant to the recommendation of the Departmental Promotion Committee had initially, while order dated 8/7/2020, been promoted as engineer-in-chief simplicity. Because a writ had to be filed, and by the petitioner, being writ number CWJC number 2327 of 2020, realizing during the course of pendency of the writ application that the promotion was granted to a non-existent cadre post, because a second DPC was constituted by the respondent authorities themselves, and in the memorandum presented to the DPC, it was pointed out that by mistake, the post on which promotion recommendation was sought was said to be engineer-in-chief. The DPC met, granted me promotion on the statute cadre post with retrospective effect, and thereafter the petitioner was promoted. Now, then I have pointed out that there is a Jharkhand Public Works Department code. In terms of Rule 15A, the post of the statutory highest cadre post is said to be the head of the branch of a particular works department, which are threefold. One is road construction department, the other is the rural works department, and the third is the building construction department. Then it also further delineates that the chief engineer is only a head of the wing of that branch. Then PWD code also contains duties and functions which are set out in Rule 291A and Rule 292 of the PWD code. This code is not an executive document. It is supposed to have been promulgated in exercise of powers under Section 162, read with Article 309, which the Public Department Code professes itself to have been issued thereunder. Then comes the transfer. A conscious decision is said that the two posts, the statutory cadre post, which has the status of additional commissioner, comes special secretary, and the post of engineer-in-chief, which was a resolution or a notification issued by the Vigilance Department, provides for sanction of two posts with a stroke. One is the post of Engineer-in-Chief Simpliciter, and the stroke is the Chief Engineer. Any one of the two could be posted as the head of that technical examination cell. The Council's decision is that the two posts are same as the pay scale is same. Now, my lords, in this IA and in this rejoinder that I have furnished 5 grounds why it is not. And those 5 grounds are, my lords, set out. Para 5 to, if your lordships will maybe make a note, it is spelled out, I have prepared, if your lordships will write. Para 5 Roman 1, 2, 3 and 4 of the IA, my lords, which is also, my lords, incorporated in the rejoinder, but in paragraph 6. My lords, what exercise the resolution dated 5/7/2002, which is the only basis on which the 3 members, Chief Secretary, the Finance Commissioner and the Secretary Personal Department took a conscious decision. If the resolution, I have brought the resolution on record, my lords, dated 5/7/2022, 2002, which is Annexure 21. My lords, it says, what it speaks about is this: it was felt expedient to revamp the technical cell of the Vigilance Department, and therefore posts were created and sanction was accorded to meet the expenditure thereof. There was one particular clause of that resolution 5/7/2002, which has been quoted in the supplementary counter affidavit, namely clause 5, says need was felt to have a competent and established honest engineers to be posted in the technical cell. Therefore, a compliment is being given that I have an established honesty and competency by my record. My lords, this is the resolution we have pointed out in para 5 Roman 1 to 4 is not in notification of equivalence, the resolution on basis of which decision is being taken. Then, my lords, the anomaly, my lords, while I was in school, I was taught in mathematics, my lords, famous proverbial A plus B plus C. Now, my lords, the notification says Engineer-in-Chief stroke Chief Engineer pay scale, same. The respondent authorities in the supplementary counter affidavit says that the statutory cadre post, which has the status of additional commissioner cum special secretary, is equivalent to the post of Engineer-in-Chief, and therefore the transfer order could have been issued. Now, my lords, take the corollary, just try to extend that. If Engineer-in-Chief is equal to statutory cadre post, Engineer-in-Chief cum AC cum special secretary, then the stroke officer, chief engineer, after what is equal to Engineer-in-Chief, equal to Engineer-in-Chief cum AC cum special secretary. Because therefore, what your lordships spelled out in your lordships order dated 15/2024 in para 3, 5 and 6, the contention of the petitioner is that petitioner has been degraded, reduced in rank, which had to be specifically answered, not a word except this conscious decision. Take that comparison. Because the post is of a chief engineer, the duties may be of a chief engineer. You, by a resolution, provide for sanctioned post of Engineer-in-Chief, which is not even a statutory cadre post, and then say that therefore the respondent
road construction department could have issued that transfer order, extended my services to a non-cadre post. It's not even an ex-cadre post. Now, my lords, next part was what?
I've got some contours of your argument. Let me just hear him and then we'll give a date, right? I've understood your main argument.
There are three more, my lords, which are equally main. Let me say that, and then your lordships.
I'll just call upon them and figure out what is
my
the
lords,
case.
I'm coming here on 15th, my lords. I'm due to remember if it could be 16th in the second half, my lords, I would be really grateful, my lords. My lords, in fact,
No problem.
my lords, I'll just give just a preface.
Yes.
My lords, would then the nomenclature as provided under the 2016 rule, which exists, my lords, which still exist even as per the oral instruction, would it impliedly stand amended by a resolution dated 5/7/2002, 14 years prior to the framing of the rules? And then, my lords, rules are framed under Article 309. Rules of executive business framed under Article 166. Clause 5, Rule 15 provides, read with entry 4 of Schedule 3, any amendment in the service condition has to be approved by the Cabinet. Could the Cabinet Vigilance Department on its own, my lords, do so? Procedure not followed. Then, my lord, kindly see this, the other aspect. Whether it's not express with duties and function and segregated as, my lords, not only orally, but in terms of Public Works Department, the orders upgrading the post of, earlier post of Engineer-in-Chief to Engineer-in-Chief cum AC cum SS. Those all notifications brought on record. Because then, in excess of that, because where was the need to have a second DPC? If Engineer-in-Chief could be interchangeably used with that statutory cadre post, and then a DPC held, and then a subsequent notification granted. Fifth is on a factual aspect.
The present transfer order is a sequel to the second DPC? Or after the second DPC your promotion was granted and therefore and thereafter?
I was posted on a cadre post.
That's right.
As Engineer-in-Chief cum AC cum SS in the Rural Works Department.
That's right.
The present transfer order takes my services back from the Rural Work Department by the Cadre Controlling Authority, that is the Road Construction Department, and posts me as an Engineer-in-Chief in a technical cell, which is not a work department. Then, my lords, I have also stated out that till date, in the technical cell, an engineer holding possibly in charge rank of chief engineer used to be posted. Never before an statutory cadre post holder, I am the highest, senior most judicially recorded, holding the highest hierarchical cadre post of Engineer-in-Chief cum AC and there are three sanctioned.
That's right.
Sanctioned post cadre post.
I got your point.
And
yes.
my lords, who are being posted there? Talking about efficiency and competence, people who have just become chief engineer or we were not chief engineer, they are all a part of records not traversed in the counter affidavit or the supplementary kind. And then, my lords, your lordships are aware of judicial orders, even the circular and resolution of the state government, that even while making an officiating arrangement, seniority cum merit is not to be ignored. That has been bypassed. Representations were filed by the writ petitioner, because they are all part of record. And while the case matter was being heard, in March itself, 2 vacant posts of Engineer-in-Chief cum AC cum were filled up by officers who were not even eligible to be considered for promotion. And that's a grievance raised, no reply given.
So the post to which you want to go back
Any cadre, any of the three cadre posts.
are already filled?
In officiating arrangement, not
In officiating
and officiation practice is what your lordships have regularly, consistently decried.
That's right.
And that too not from an officer, not even eligible of the rank.
That's right. Yes.
And Manoj, I have given a table chart. This is a practice going on right from the date I was promoted to this practice. In fact, the other point that I have set out in my petition is, which is a point possibly bears out from the facts set out in the writ petition itself. I have had to file 4 writ petition or contempt petition for seeking consideration of my promotion, for grant of arrears of my salary, for period of posting, waiting for posting. In all those 4 writ petitions, they were all part of the pleading. Orders were issued. In fact, there is an order in contempt of this Honorable High Court with regard to issuance of a notification, which says that possibly the respondents are trying to play with the orders of the court. That's recorded judicious.
It's an observation in a contempt order.
I'm
that will not cut much ice.
But then, the various facts suggest, my nose is not liked by the respondent authorities at all. No.
Yes, tell us. What is your case? It is equivalent?
Yes, I will assist your
Kindly,
lordships on
kindly.
that.
Yes. You assist. Kindly have a seat for some time.
Firstly, your lordship may kindly see the DPC meeting. Page 40 of the writ petition annexed. The minutes of it.
This is pursuant to the order of the court.
Pursuant to the order.
What do you want to show?
The para 2 I am reading from para 2.
You just tell us contours of your argument because we are not finally hearing it
Madam,
today.
then
I just want to
my
know that what
argument
is your
this.
case.
My argument is this. But on the basis of the order passed by this honorable court, according to which a DPC was convened. My lord, the petitioner was promoted to the post of engineer-in-chief in Rural Works Department.
Come additional secretary perhaps.
No, firstly, Rural Works Department as engineer-in-chief. But this DPC, the handing of the decision of the DPC and the observation of the DPC, it says that one post of engineer-in-chief come a special secretary, cadre post transferred from after bifurcation from the state of Bihar in the road construction department, RCD. Thereafter, my lord, on 14/8/2001, one post of the same nomenclature and designation was sanctioned and created in the rural works department. Again, my lord, on 17/3/2006, one more post was created in the building construction department. My submission is this, my lord, the 3 departments, the road construction, rural works department and building construction department is the works department of the government. Here, my lord, in the works department of the government, an engineer-in-chief has to perform some other duties also, the responsibilities. That's why, my lord, the nomenclature in the 3 works department, the designation and the nomenclature of the post will be engineer-in-chief, come additional commissioner, come special secretary. But the basic post is engineer-in-chief. What is, my lord, come? Come is a preposition. It is as well as in addition to. But an engineer-in-chief, if required by the state government to some other department by the resolution of the state government, he will not be treated as the special secretary and other designation attached with the engineer-in-chief. Because the responsibilities are different there.
There is no cadre post as engineer-in-chief, come special secretary, come additional
in the vigilance department.
In the rules.
rules there is.
Then
But for the three departments, what my submission is for the works department. Matlab the cabinet vigilance is not the works department. There his responsibilities and functions are slightly different.
He is sent
Here
on
he will
deputation.
see one department.
Is he sent on deputation or he has been sent on transfer?
He was sent on transfer.
Transfer is different from deputation. Transfer is different from deputation,
Yes,
isn't it?
But when the post under the building construct department was constituted, sanctioned and created, all the three posts will be under the road construction department, and it says that the road construction department can मतलब हिंदी में है कि उसकी सर्विस ली जा सकती है और कहीं दी जा सकती है. I will read Manobandi Adala. And second point, my senior is that it is a reduction. Malad, it is not a reduction. Reduction of post, if an engineer in chief is posted to the post of chief engineer, which is the feeder post of the engineer in chief, then it will be, it can be said that it is a reduction of post.
He is promoted to engineer in chief and he has been posted as engineer in chief. This is what you want to say?
No, he was promoted to the post of engineer in chief, but the notification was of engineer in chief in the works department, but in the works department three posts are sanctioned of the engineer in chief, whose nomenclature will be additional commissioner.
I want to know from you. According to you, he was promoted to the post of engineer in chief.
From the
Forget
post
about come.
Yes,
right?
From the post of chief engineer.
Chief engineer.
Yes.
And he has now been posted as engineer in chief in the vigilance department.
Vigilance department.
As engineer in chief.
Engineer in chief.
Where is that cadre post in the rules?
No, he was referring to page 40. Kindly turn to page 14.
May I complete?
Yes, yes.
He is possibly half-only telling it. अनुशंसा अभियंता प्रमुख सह अपर आयुक्त सह विशेष सचिव के पद पर दिनांक 24/12/2019 से के प्रभाव से वैचारिक रूप से.
I am not saying that it is incorrect because it is in the DPC. It has to be. That post has to be allowed in the
We'll
works
hear it on
department.
16th.
Yes.
We'll hear it on 16th.
13 months.
On 16th at
250, yes. Because first half there is already a matter fixed.
That's right.
Therefore.
The learned counsel for the parties have given the contours of their respective arguments in connection with the issue involved in the present case. Pose this case for further hearing on 16th of April to be taken up at 2:50.
Lords, I am very
As first
thankful to
case.
my learned friend. Lords, one quality I admire, never be shy of getting a case heard, adjudicated. And therefore I compliment
Though
my
he
friend.
never does.
Lords, and second compliment is, he admits, my functions and responsibilities are different in the vigilance. Now is there, and therefore your Lordship said, I had given a copy of the judgment.
Yes, that's so well.
We'll see.
Under heading for orders with defect, item 6, criminal revision 5/1/2020.
Yes, petitioner.
Paying for 1 to limitation delay 91B and CC of order dated 21 to 5/1/2020.
8283 has also been issued against you. Yes. 8283 has also been issued against you. Earlier on 4/3/2022, process under section 82 was issued against the convict, but no service report was issued, and then is absconding. What is the defect which is required to be removed?
Surrender certificate limitation on limitation 91 days.
We'll dismiss the case. We will not grant you further time. By way of last chance, it was already granted. Criminal Revision number 51 of 2022. The learned counsel for the petitioner prays for further time to remove the surviving defects. On 24 August 2021, in spite of repeated calls, nobody had appeared on behalf of the petitioner. It was recorded that the revision application was filed on 14/1/2020, but the surrender certificate was not filed and other defects were also not removed. However, by way of last chance, 3 weeks' time was granted to the petitioner to remove the defects and either to produce surrender certificate or to deposit the fine amount as directed by the learned trial court, failing which the concerned court was directed to take all possible steps for apprehension of the petitioner and commit him to jail for serving the sentence. Thereafter, the case was taken up on 24/2/2022, and it was recorded that even till date, neither the limitation petition nor the surrender certificate was filed. The court concerned was directed to take all course steps for apprehension of the petitioner and commit him to jail for serving the sentence and report to this court within 3 weeks. A report has been received from the concerned court indicating that on 4/3/2022, process under section 82 CRPC was issued against the petitioner, but no service report was received. It was also recorded that, considering this fact, on 12/3/2024, considering the fact that the convict was absconding, on 12/3/2024, the court had issued process under section 83 against the petitioner for attachment of his property. This court finds that, in spite of repeated orders and opportunities, the petitioner has not removed the surviving defects. And today also, and accordingly, this court is not inclined to grant any further time to the petitioner to remove the defect. Accordingly, this revision petition is hereby dismissed. Appearance, did you have?
Item 7, criminal resolution 749/2021.
Should we need 2 weeks time to remove the defect?
Were you ever granted time?
We have received this file in last of December. Earlier, another advocate was appearing. We have appeared through NOC matter. After that, we have removed several defects. Only 2 surviving
You
defects.
took a NOC from the earlier council and never appointed anybody. And when this court has sent you invitation card through notice,
No, madam.
now you are appearing.
After that,
Now please don't try to explain things like this, right?
Madam,
Yes.
after that, we have inspected the file and already removed the several defects. And there are 2 only 2 defects are remaining.
What all are the
regarding
defects which are remaining?
Regarding type copy, my lord, 9, 3, 4 and 6, which are regarding type copy, and 9, 4, 5 is regarding supplementary affidavit.
Supplementary
Yeah,
affidavit?
we have to file supplementary affidavit regarding that this petitioner have ever moved before the session court or not.
Your protest petition has been rejected.
Yes, ma'am. Yes, ma'am.
What is the nature of the impugned order? You argue your case.
Petition type copy करेंगे.
छोड़िए ना, बिना टाइप कॉपी के पढ़ लें. बताइए क्या है आपके पास?
मंडे को जब दिए कल पिटीशन टाइप कॉपी करेंगे. 30 पेज का टाइप कॉपी करना था. वेकेशन पहले ही.
The learned counsel for the petitioner is present. He submits that he has appeared before this court after notice was served upon the petitioner through speed post and also through the concerned police station. The learned counsel submits that some more time be granted to remove the surviving defects. Time till 12th of April is granted to the petitioner to remove the surviving defects preemptively. If the defects are removed by 12th of April, pose this case on 19th of April under appropriate heading. 19th to 18th.
Under heading for orders item 8, criminal revision 9 of 2019.
My lords, this is a case of NIA. It is the joint compromise we filed yesterday. The IA number is 3317 of 2024.
What are the terms of compromise?
Terms of the compromise, my lords, that the entire amount has been given to the complainant, handed over to the complainant, and one annexure I have also annexed with joint compromise petition that they have already entered into the joint compromise on 2/5/2024. The annexure is there, my lords.
Where is that?
Annexure A, page number 12 in IA. I have already made agreement before. And my lords will see page number 15. May I read that?
Any objection?
No.
You are for OP number 2?
Yes, Lord.
What is the name of your client?
Yes, Lord.
What is the name of your client? You
Second
have वकालतनामा here?
Second Singh. Yes, Lord.
Your वकालतनामा?
Yes, Lord.
कहाँ है इनका वकालतनामा? What is your name?
Ramesh Kumar Singh.
देखिए, the learned counsel for the parties are present. The learned counsel for the parties submit that IA number 3317 of 2024 has been filed by way of joint compromise petition.
Yes, ma'am.
The learned counsels have jointly submitted that the parties, that is petitioner and opposite party number 2, have settled the matter out of court and they have no surviving grievance against each other. The learned counsels have also submitted that the terms of the compromise has already been brought on record along with the interlocutory application. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, whereby the petitioner was convicted for offence under section 138 of Negotiable Instruments Act. The present petition is disposed of in terms of the compromise. That should be sufficient. Sorry? The sentence, since the parties have settled the dispute, the impugned order passed by the learned trial court as well as the judgment of the learned appellate court are hereby set aside. Okay.
I am admitting we have requested.
The learned counsel for the state is present. He submits that he has no objection for the compromise between the parties as the offence is compoundable in nature. That's it.
Item 9, criminal revision 133 of 2019.
In this case, your lordship, the opposite party number 2 has died. We have filed an application, supplementary affidavit, your lordship, bringing on record the death certificate.
The case has become infructuous.
So his name may be deleted.
Only opposite party number 2 has accepted.
Only opposite party number.
Where is the IN?
No,
IN number?
supplementary affidavit filed on.
Any objection? The learned counsel for the parties are present. The learned counsel for the petitioner submits that the opposite party number 2, namely Lakshman Roy, son of late Birbal Roy, has expired during the pendency of this case. His death certificate has been placed on record through the supplementary affidavit dated 2/4/2024. He has died on 30/4/2022. The learned counsel submits that the name of opposite party number 2 be deleted. The learned counsel appearing on behalf of opposite party number 3 and 4
Yes.
has
I
no
was appearing
objection.
for 2 also.
So, the learned counsel appearing on behalf of the opposite party number 2 to 4 has no objection to the prayer made. Accordingly, the petitioner is directed to delete the name of opposite party number 2 from the cause title in reading during the course of the day. Yes, further?
Further, Your Lordship, we have challenged the order dated 24/1/2019, wherein cognizance of the offences only under sections 323-504 of the Indian Penal Code has been taken by the learned magistrate. Although, specifically, Your Lordship, all the allegations leveled and also in the evidence of the witnesses, Your Lordship, it constitutes a case under section 498A as well as 3/4 of the Dowry Prohibition Act. Please just have a look to the complaint case itself.
What is the stage of the case? There is a stay?
No appearance stage, Your Lordship.
At the stage of appearance?
It is at the stage of appearance, Your Lordship. The next date is 8/7/2024.
All right. Yes, what do you have to say on the point of cognizance?
Look, firstly, Lord, this revision, Lord, is not maintainable. Look, because Lord, he has all the opportunity, Lord, at the time of framing of charge, Lord. Look, we can raise all these points in the trial court itself. But secondly, Lord, here the opposite party number 2, 3, 4 are Sasur, Jade, and Devar. Lord, husband is with her. Lord, how can husband is residing with her? There is no dispute with the husband. How can Sasur demand dowry when husband supports her wife?
I do not know. That is for you to answer to your client. Don't ask us
And Sasur
how can you do it.
और ससुर अब है भी नहीं. अब बचे बस जेठ और देवर. Look, they are demanding dowry, and husband is in support of his wife.
Is there no
Really?
likelihood of any kind of compromise, Mr. Tiwari?
Your Lordship,
It appears that there was some, because is the husband living with you?
Yes, Your Lordship.
But
Now,
still
Your
you want
Lordship, they are inimical to the husband because of the present wife. What is the allegation? Please just have a look to the allegations, Your Lordship.
Will it suffice that, you see, cognizance is basically taken against in connection with the offence. If I just want to know from you that if a particular section is not mentioned in the cognizance order, is there any legal bar in framing a charge under that section?
Yes, Your Lordship. One step will already go away. If cognizance is not taken, Your Lordship, I can challenge it by way of a revision application, and my learned friend is not correct to say that revision application will not lie. Any order passed by the learned magistrate,
No,
Your
it is
Lordship,
revisable order.
it is
There is no
revisable.
problem about it.
Now, Your Lordship will please see. There was a evidence of the witnesses. In a complaint case, Your Lordship, section 200, thereafter 201, 202. All the 4 witnesses have categorically stated about demand of dowry. And Your Lordship, torture meted to the lady. But in spite of all these facts, in the notice of the learned magistrate, cognizance of the offences has not been taken under the required sections, and it is not according to law to say that all this can be taken at the time of framing of the charge. Cognizance is a separate issue, charge is a separate issue, all are. So why should the lady not be given the opportunity of the remedy which is provided under the CRPC? Now, Your Lordship, section 190, Your Lordship will please see, wherein cognizance of the offences are taken by the learned courts.
Look, Cognizance is prima facie.
No, you just tell us.
Yes.
Was there enough material on record to have a prima facie case under section 498?
Look, he has not shown that.
I'm just asking you. If you say no, I'll ask him. There is no material. The
Look,
moment you say
look,
no, I will immediately ask him.
Against opposite party number 3 and 4, there is no material.
Okay. Now, Mr. Tiwari, he
Paragraph-
says there is no material.
Paragraph 10, Your Lordship will please see of the complaint.
No, we will see the essay and complaint by itself is not sufficient.
Yes, Your Lordship.
It is the essay and the evidences which have been produced would be important. Where is the complaint? Let us have
Complaint, Your Lordship, is annexure 1.
Yes. Which paragraph are you showing? And then
Paragraph
we'll
10,
see.
Your Lordship.
Para 10?
And paragraph 4 and thereafter, Your Lordship. Paragraph 4.
Yes.
And that soon after the marriage, all the accused persons tried to instigate the complainant.
Paragraph 10.
4.
Petition. Complaint petition.
Yes.
To instigate the complainant husband against the family members of the complainant for not arranging proper wedding and bringing sufficient dowry as per the social status. That for the last 5 years, the complainant has been suffering physical, mental abuse, pain, helplessness, unhappiness and anger on account of the accused persons. That the complainant was not given, and specific paragraph, Your Lordship, this is the main thing which needs Your Lordship's consideration, that the complainant was always insulted, ridiculed, humiliated and taunted, especially by her in-laws, with regard to not having a child. That thereafter 10, 9 and 10, very, very important, Your Lordship. That the accused persons always insulted the complainant in presence of his friends, brother, father, relatives, who often visited the house of the complainant. Several incidents had taken place of such type. Accused always started taunting for dowry and also fought with the complainant's father in front of the complainant and her husband publicly, which brought huge embarrassment, shame and agony to the complainant. So paragraph 9, Your Lordship, only because of the fact that she was not blessed with a child, and thereafter, Your Lordship, insult, everything was done to her. This brings it within the ambit of section 498.
Where is her essay? This was preceded by an FIR.
No, FIR we had given earlier, Your Lordship.
In FIR?
And in FIR, when no action was taken, then only we had to.
FIR was registered.
Not registered. That is why we filed a complaint.
Annexure 2 is what?
Annexure 2, Your Lordship, only it was registered and no action was taken. Your Lordship,
That is a
please.
separate thing, no? FIR registered, no action taken is one thing. FIR not registered, then only a complaint case is filed.
Yes, Your
normally.
Lordship, that was done.
And look, in
What
FIR
happened to the FIR case?
That is still pending, Your Lordship. This was. Firstly, this was filed, Your Lordship. This was filed on 22/2018, and thereafter this FIR was registered. This was for another offence, Your Lordship.
The complainant is an advocate.
Yes.
She was an advocate, Your Lordship. Now she has.
At the time of
Filing
lodging these
the
cases, not she was advocate.
But now, Your Lordship, she is in the service of the government.
There is no statement in the complaint in the line of Priyanka Srivastava. There is no statement.
Priyanka Srivastava, Your Lordship, will come at a later stage. because of the fact cognizance of the offences under section 3.
Priyanka Srivastava says that in the
Relatives cannot be
complaint,
harassed.
complaint has to be supported by an affidavit, and then the complaint should also disclose that they have gone to the police station for filing a case, and having not registered a case, the complaint case was filed. That is not there.
After police station, the complainant has to go before SSP also. Now, statement.
There is no such statement, so I was just wondering how this case has been registered. Not even one statement. Where is the essay? Where is the essay? Where are the deposition of the witnesses?
The depositions are there.
The essay is the most important thing. She is the complainant herself. Statement made in the complaint case will not decide anything. It is the essay which will decide.
Essay we have not filed, Your Lordship. Yes.
That's your problem.
कल का डेट में कैसे दिखा है
इसमें supplementary affidavit filed. Who has filed a supplementary affidavit in this case?
We have filed, Your Lordship.
Saying what? You have not even informed this court that you have filed a supplementary affidavit. Annexure 6 is what? What supplementary affidavit have you filed?
Supplementary affidavit, Your Lordship, this about the death.
Oh. Okay. What is Annexure 6, page 86?
That is the evidence of the complainant.
Is this the essay?
Yes, Your Lordship.
Can you read it? It means that you have not read it.
No, I have read it. It is already marked.
No, you said that the essay is you have not filed. So I'm just wondering.
That I was only confusing, Your Lordship. I have already marked it. Your Lordship, may please see. Annexure 6, page 86.
You come to the relevant paragraph where you have made specific allegation against opposite party number 2 and 3.
I will read that.
Tell us.
Annexure 6, page 86, paragraph 1, the last 3 lines.
Okay.
शादी के बाद मैंने अपने ससुराल हिनू आ गई. शादी के 15 दिन तक सब कुछ ठीक चला. 15 दिन के बाद से ही मेरे ससुर जी, मेरे देवर मुकेश कुमार दहेज को लेकर मुझे प्रताड़ित करना शुरू कर दिए और 5 लाख रुपये का डिमांड करने लगे. Has your lordship got that?
Yes. Sasur and Devar.
Sasur and Devar.
Or OP number 2 is?
Sasur.
2 is Sasur, who has expired.
Expired.
And
thereafter, your lordship.
3 is?
3 is Lord Jade.
3 is Jade.
Mukesh.
Yes.
मुकेश
देवर नहीं है ना?
मुकेश इज देवर.
मुकेश का ही नाम दिया हुआ है. मेरा देवर मुकेश कुमार दहेज को लेकर मुझे प्रताड़ित करना शुरू कर दिए.
That's right.
और 5 लाख रुपये का डिमांड करने लगे. Thereafter, your lordship. पैराग्राफ 2. मैंने अपने मायके में बताया कि मेरे साथ ऐसा व्यवहार किया जा रहा है. पैसा को लेकर ससुर एवं देवर द्वारा प्रताड़ित किया जा रहा है. Thereafter, your lordship, skipping 2 lines, फरवरी 2013 में मुकेश कुमार ने मेरे पति के साथ हाथापाई के बीच बचाव में जब गई तो उन्होंने मुझे भी धकेल दिया और मारपीट किया. जब मैंने इसकी शिकायत ससुर जी के पास की तो उन्होंने मुकेश कुमार का साथ दिया. Thereafter, your lordship, paragraph 3, and the 3rd line from the bottom, वर्ष 2015 में मेरा भाई मुझसे मिलने आया तो मेरे ससुर और मुकेश कुमार ने मेरे भाई से शिकायत की, गाली गलौज किया और दहेज की मांग की. उस वक्त वहां पर मैं, मेरा भाई, मेरा पति मौजूद थे.
Okay, this we have seen. Now, what about Amitesh Kumar?
Yes, your lordship. Please just turn to the next page. Page 87.
Yes.
The 4th line from the top.
Yes.
अमितेश कुमार और मेरे ससुर जी मुझे धमकी देते थे कि बहुत वकील बनते हो, सारा वकालती भुला देंगे, ऐसा फंसाएंगे कि बचाव का कोई रास्ता नहीं रहेगा. अमितेश कुमार का क्रिमिनल एक्टिविटी रह चुका है, वो जेल भी जा चुके हैं. वो मेरे ससुर को कहते थे कि बिजली काट दीजिए, पानी बंद कर दीजिए, और मेरे ससुर जी ने ऐसा ही किया. हमारा पानी बिजली बंद कर दिए. ऐसा इसलिए करते थे ताकि मैं दहेज की बाकी रकम जल्द से जल्द लाऊं.
Yes, opposite party.
Not against
We will
Mukesh
only
Kumar.
see the. अभी तो कुछ क्रॉस एग्जामिनेशन का कोई बात नहीं है.
मुकेश कुमार के अगेंस्ट में तो दिख रहा है.
अमितेश
अमितेश के अगेंस्ट में जो है, that is not regarding दहेज.
दहेज एंड टॉर्चर दोनों.
अमितेश के
No, the order cannot be sustained.
And Lord, my submission is, Lord, he has all the opportunity to
No,
raise all
no,
these
no,
points at the
no.
time of framing
We'll
of charge.
We'll see that.
And Lord, there are cases and counter cases between the parties.
Maybe.
Lord, in
How
this
are we
case,
concerned at the stage of cognizance? We are not concerned with case and counter case, right? तो cognizance यहाँ से होगा कि कोर्ट में होगा नीचे? Just a moment.
Your lordship will direct the learned magistrate to take into consideration and thereafter pass a reasoned order under section 190, taking into consideration.
Then this order has to be set aside.
No, your lordship. This order will go.
Fresh order.
And fresh order will be passed on the basis of the materials.
देखिए, the learned counsel for the parties are present.
Lord, one fact, Lord. This
पार्टियां
Amitesh
लिखाए
Kumar-
हैं एक का डिलीट होने का. आपने लिया किसने लिया? Yes, एक पार्टी के डिलीट होने का डिक्टेशन. हाँ, उसी के कंटिन्यूएशन में. The learned counsel for the petitioner. This petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the complaint case was filed before the learned court for alleged offence under various sections including section 498 of Indian Penal Code. However, the learned counsel has further submitted that in support of the complaint case, the solemn affirmation of the complainant has been recorded. He has referred to the various paragraphs of the solemn affirmation of the complainant recorded on 5/4/2018 and has submitted that there are ample allegation against the opposite party number 2 and 3, 3 and 4, with regard to demand of dowry and torture, the learned counsel has submitted that at the stage of cognizance, only prima facie case is required to be seen, but the learned court has omitted to take cognizance under section 498 capital A of Indian Penal Code. He has submitted that the impugned order dated 24/1/2019 is completely silent in connection with the ingredients of offence under section 498A as mentioned in the solemn affirmation. The learned counsel appearing on behalf of the opposite party number 3 and 4 has opposed the prayer and has submitted that the various offences for which a case is made out is required to be seen at the stage of framing of charge, and therefore the order impugned need not be interfered.
So, एक बात है. So this is a complaint case. Lord, she is a lawyer. She was a lawyer. Lord, she has filed complaint case. Lord, she had all the opportunities to make all allegations. Lord, at the time of filing of this complaint petition, Lord, she did not do that. Lord, in solemn affirmation, Lord, she has, Lord, now we can see, Lord, that allegations are completely aggravated, Lord. Lord, this cannot be done, and your Lordship may see, Lord, Priyanka Srivastav also comes in between, Lord. Lord, there is no statement regarding, Lord, whether they had gone to the police station, whether they had gone to the SSP.
The learned counsel for the opposite party.
And Lord, opposite party number 3 resides separately, Lord, due to these.
Opposite party
files.
number 3 and 4 has also submitted that the petitioner is was a practicing advocate at the relevant point of time.
In High Court, no, she was practicing.
High Court.
Yes.
At the relevant point of time, and
Lord, the marriage was.
And therefore the details in connection with the allegation ought to have been mentioned in the complaint petition itself. But the details which have been mentioned in the solemn affirmation is completely absent in the complaint petition.
Complaint petition कोई ऐसे specific allegation किसी के against में.
He submits that
accused persons.
There is no specific allegation in the complaint petition. No specific allegation against the complaint in the complaint petition in connection with the opposite party number 3 and 4, and therefore the impugned order does not call for any interference.
But their marriage is a love marriage. The husband is with her.
इतना कहानी हम आपका कंप्लेंट पिटीशन के सोलम एफर्मेशन में सुनेंगे और लिखेंगे.
नहीं बस मेरा बस सबमिशन है कि ये
नहीं इतना देखिए, it can't be like this. There is a limit to which at the stage of cognizance your defense and all these things can be taken into consideration. We have our own limitation. Advocates do not have any limitation.
But courts, husband उनके साथ रहते हैं तो ऐसे में.
The learned counsel has also submitted that the case is a false case in as much as the husband of the petitioner is residing with the petitioner. Right?
In agreement.
After hearing the learned counsel for the parties and considering the materials placed on record, this court is of the considered view that the impugned order dated 24/1/2019 has not taken into consideration all the materials which were placed on record at the stage of cognizance. Although the learned court has recorded that the complainant had supported the case as made in the complaint petition and had also produced witnesses in support of the complaint. This court also finds that nothing specific has been recorded with regard to the alleged offence under section 498 capital A of Indian Penal Code, and cognizance has been taken only under section 323 and 504 of Indian Penal Code. After going through the impugned order dated 24/1/2019, this court is of the considered view that the learned court has failed to exercise power in accordance with law while passing the order of cognizance. It appears that the materials placed on record have not been properly appreciated by the learned court below. Even if this court is of the considered view that the impugned order does not reflect application of mind in connection with alleged offence under section 498 capital A of IPC. The impugned order, in such circumstances, the impugned order calls for interference under revisional jurisdiction. Accordingly, the order dated 24/1/2019, impugned order dated 24/1/2019, give the details of the case, is hereby set aside and the matter is remitted back to the learned court for passing fresh order in connection with cognizance after appreciating a fresh order in connection with cognizance in accordance with law within a period of 15 days from the date of communication of this order. This petition is accordingly disposed of. Communicate.
After taking into consideration the materials.
That's right, in accordance with law, I've already said.
Item 10, Criminal Revision 195 of 2019. So, Passover case.
आपका केस कॉल आउट किया,
Item
इनका
four.
कॉल कर लीजिए. आइटम 10 इसका.
Item 10.
Yes, petitioner. Yes.
In this case, my lord, the petitioner has been convicted, thereafter filed appeal. Conviction order has been affirmed in appeal. After that, he referred before this honorable court, in which he has been granted bail by this honorable court. And by subsequent order,
You have not filed requisite for.
Yes, my lord. This is the default on the part of either my client or my party. I am not able to say that we had done this mistake, either my client or by myself. I am not clear. But I will comply the order within a week, my lord, if I will given a single date, my lord.
Earlier also time was granted to you
Yes,
to file
ma'am.
requisite.
I am not able to remember that
There is no question of further time.
mistake was done by whom, either by my client
Repeated
or...
mistake. You pay some cost, I will grant it.
Very poor person, my lord. A little-
Cost, I will give you time.
a
You have to
little
pay cost. Right? You will take interim order from the. Are you complying with the order passed by this court so far as your marking your attendance is concerned?
Yes, ma'am.
You have been convicted
Yes, ma'am.
in a case filed way back in 2006.
Yes.
Look, criminal revision is against the judgment dated 15/9/2006.
Yes.
Filed when? In 2019.
19. As because he went outside the state matter
1
for
lakh
his
रुपए cost
livelihood.
करेंगे. 1 lakh rupees. 1 lakh rupees cost करेंगे.
He is not able to pay one.
कोई बात नहीं, तो अपना आराम से जेल में रहेंगे, कहाँ कोई मनाही है, वहाँ खाना पीना बढ़िया मिलता. There is no problem.
Laborer, my lord, and due to livelihood, he went to outside the
बहुत
state
स्मार्ट
matter.
लेबरर. क्रिमिनल अपील जो है 2006 में डिसमिस हो गया. कितना दिन का डिले है?
Jawali's account.
This petition IA has been
Limitation has been condoned.
Has been
Delay
condoned?
Yes. Thereafter, he has been enlarged on bail.
देखिए क्रिमिनल रिविजन नंबर 195 of 2019. The learned counsel for the petitioner prays for adjournment, and he submits that in spite of order passed by this court, the requisite for service of notice to the opposite party number 2 has not been filed. He submits that some more time may be granted so that the order of the court is complied. From the perusal of the records of this case, it appears that the case was admitted by the order dated 25/9/2019, and a direction was issued to issue notice to opposite party number 2 for which requisites were to be filed under registered cover and ordinary process by 18/10/2019. And the petitioner was also admitted on bail with the condition that he will mark his attendance once in every 3 months in the office of registrar cum judge in charge civil court Godda till the disposal of the petition. In spite of the order, the order was communicated to the court concerned, and a letter bearing number 709 dated 10/7/2020 was received from the judge in charge regarding non-appearance of the petitioner for marking his attendance once in every 3 months. And it was also observed in the office note that the requisite for notice were not filed by 18/10/2019, and a memo of reminder was also sent to the Learned Counsel. Thereafter, the case was taken up on 12/10/2020, and by way of last indulgence, 2 weeks' time was granted to file requisite of notice. And the court concerned was also directed to issue show cause to the petitioner that if he does not mark his attendance before the judge in charge, Civil Court Godda, by 21st October 2020, then a bailable warrant will be issued against him. And ultimately, a letter number 1028 dated 8/12/2020 was received by this court regarding attendance of the petitioner in the office of judge in charge, Civil Court Godda. However, the requisite for service of notice upon opposite party number 2 has not been filed, and the matter has been posted today. When the case is taken up, now the petitioner is seeking adjournment and prays for time to comply the prays for time to file requisite for service of notice upon opposite party number 2. Considering the aforesaid facts and circumstances, time till 8th of April is granted to the petition. 10th of April is granted to the petitioner to comply to file requisite for service of notice upon the opposite party number 2 under registered cover as well as ordinary process. Subject to a cost of rupees 25,000 to be deposited by the petitioner in Jharkhand Legal Services Authority, and the receipt of the same be filed before this court along with the be filed before this court by 9th of April 2024. In case the cost is not deposited or the requisite is not filed within the aforesaid stipulated time, this revision will stand dismissed without reference to the court, and the office shall forthwith communicate the fact regarding dismissal of the revision petition to the court concerned, who in turn would ensure that the petitioner serves the sentence as passed by the learned court concerned, as passed by the learned court.
कुछ कम कर दिया है रद्द नोटिस
बढ़ा सकते हैं
उसका रिजल्ट तो डायरेक्ट है कि डिसमिस किया है वो दे तो नहीं सकेगा।
नहीं दे सकेगा, कोई बात नहीं।
एक
चलो
Item 12 premium action. The passover case item 4 WPS 1291 of 2023.
In this case, my lord, the petitioners are working in London Park, my lord, the registration since the year 99 onwards.
who is giving you salary?
Deputy Commissioner Devan, my lord.
Where is the proof?
Annexure 8 at page 38, my lord.
Annexure 8.
Page 38.
No, this is basically being given through this Manoranjan Park, Nandan Pahad Manoranjan Park. Right? It is not a payment of salary.
They are being paid honorarium, my lord, since the year 99, my lord. And they are under the control of the Deputy Commissioner Devan, my lord. They are not under the control of any contractor or otherwise, my lord.
Is there any sanction vacant post?
Yes, my lord, annexure 9 at page 9, my lord, page 42. Page 42, the last, my lord. सेवक समाज चतुर्थ स्वीकृत पदों की संख्या 155, कार्यरत कर्मी 69, रिक्त पदों की संख्या 86. It is the letter of 15th March 2021, and since the year 2001, till date no vacancy has been advertised by the Deputy Commissioner. That's why they are taking work from these persons on daily basis, and under the assurance that they will be granted relief at the time of regular appointment.
Yes, madam, what is your case?
Your Lordship, initially the management of the said Nandan Park was given to a private operator. And the private operator engaged the required workforce and managed the same for more than 3 years. After that, the management committee of the Nandan Park itself started taking care of the development and all. And
You see, your payment is as late as on 21/2023. Yes. Then why this deputy commissioner is involved in making payment?
Your Lordship, he is a part of the committee, Your Lordship. Committee, the details of the committee is in Annexure A. A committee has been formed, Your Lordship, for the development and the management of the Nandan Bihar.
Does it belong to the state?
No, Your Lordship, no financial aid is in para 15. It is
No,
stated.
it is a government property.
It is a self-financed body, Your Lordship.
Which is that self-financed body?
Amusement park.
From where do I get that?
Para 15 of the counter it is stated, Your Lordship. May I read? This park is a self-financed body and does not receive any government fund, neither has any recruitment process followed, nor any eligibility criteria looked into by the answering respondents with respect to the petitioners. The petitions are not working for the
Para number
Collectorate or for any other office under the district administration. Rather, they work in a park, therefore the petitioners are not entitled for any relief as prayed for in
the park is being maintained by the government. From what is the source of making this payment?
Yes, initially it seems that
yes, it is being paid by the government.
I think there is a yes.
Where is your appointment letter?
The appointment is not issued to the petitioners.
How long have you been working?
4
Have they
months.
considered your claim for regularization?
I have submitted my petition for the Deputy Commissioner, it is still pending.
Where is your
Annexure 10.
representation?
Annexure 10 at page 43.
Yes, madam.
Your Lordship, when the contract has been made, it was stated in बंदोबस्ती की राशि नंदन पहाड़ विकास समिति के नाम से बैंक में जमा की जाएगी. तो उस समिति के नाम से जो भी उसका रेमुनरेशन आता होगा, जिससे भी टिकट से
आप
सबसे
हमको
वो उस
इतना
बैंक से ही
बताइए कि
पेमेंट होता
ये
है।
पैसा कौन दे रहा है? Who is making this payment? The government?
Yes.
Then?
Ultimately, government.
Government only?
Yes.
Then? रेगुलराइज नहीं करने के लिए छोटा छोटा यूनिट बना दें, समिति का नाम और इसका नाम। यू हैव फाउंड आउट वेरियस डिवाइसेस टू एक्सप्लॉइट। रेगुलर एम्प्लॉयमेंट नहीं करना है, इन लोगों को वर्षों तक खटाते रहना है और इनको एक्सप्लॉइट करना है, इनको बंधुआ मजदूर बना के रखना है, डर के साथ रखना है कि जब मन होगा हटा देंगे और कोई नहीं होगा आपको बचाने वाला। Yes? What is this? Is it not exploitation?
Petitions also reached the court very belatedly, Your Ladyship, after
Belatedly?
19
पहले आ जाते तो भी आपको पसंद नहीं आता। कब से काम कर रहे हैं आप? 99 से काम कर रहे हैं। They come within the purview of 2015 circular.
But Your Ladyship, that is for the state employees and
ये सैंक्शन वेकेंट पोस्ट है ना, इसी में आप कंसिडर करिए। सेकेंड आपने लिखा है, नहीं कर सकते ऐसे, इतना एक्सप्लॉयटेशन नहीं कर सकते। यू विल नॉट गिव देम अ डिसेंट लिविंग ऑल्सो। कितना टैक्स लेते हैं हम लोगों से? डू यू हैव एनी आइडिया? डायरेक्ट इनडायरेक्ट टैक्स मिला के कितना पैसा जाता है? क्या करते हैं सब? गाड़ी खरीदते हैं, यस? काम करने वाले को पैसा नहीं देंगे, एक्सप्लॉइट करते रहेंगे ऐसे। The second half I'll pass the